Today's cha-ching cha-ching is the ching 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 crash of a supermarket trolley crashing into a car. So we're circling back to the shopping mall parking lot in the second hour of the show. Wendy Knowler with us for Consumer Talk. And a couple of you already sharing your experiences of damage caused by shopping trolleys. We'll weave that in as well. But we are going to talk about a particular case that raised some interesting questions around who is liable when accidents like this happen. After that, I hope we'll have space for some open line calls as well. So you're welcome to start sending those comments and questions through on the WhatsApp line in advance. And Wendy, welcome back. Great to have you with us.
Great to be here, Pippa. Thanks.
We've all seen that person who unpacks the groceries into the boot of the car and then doesn't take the trolley back to the designated area, just pushes it out of the way of their vehicle and drives away, and off they go and don't give it another thought, Wendy. Meanwhile, that trolley ends up posing a potential risk to other shoppers' vehicles. Maybe it isn't actually stable and parked. It's going to roll into somebody else. So we're aware of how this problem happens, but tell us why we're talking about it in this particular episode of Consumer Talk.
Okay, well, we have a case study. To start, obviously, a trolley is a shopping basket on wheels, and when it's on a slope, even a slight one, it's about 20 kilograms of plastic and steel reinforcement on the move, and that's really not something you want barreling towards your parked car. So, the case study. On the morning of the 9th of June, Michael Mwanza of Plumstead parked on Victoria Road outside ShopRite Southfield and went into shop. He came out to find a shopping trolley still lodged against the side of his car and a member of the public standing there waiting to tell him what had happened.
That's very kind of that said member of the public to wait.
Yeah, indeed.
Okay.
So the trolley had been standing unattended. Apparently, in the industry, they call them orphaned trolleys.
Okay.
On the pavement outside the store's main entrance. It rolled down the slope into the road and hit Michael's car. And it mattered to him more than it would many of us because Michael is an Uber driver and the car is his living. It is insured, but he rents it from its owner. He showed me the contract and he carries the excess liability, insurance excess himself. So every rand of this was going to be coming out of his own pocket.
Yeah.
And so he was asked by the store to get 2 repair quotes, just so we know what amount we're looking at here. The lowest was 9,300 odd and the highest was just over 12,000.
And again, so if that's coming straight out of your pocket and plus the inconvenience of that car not being available for you to carry on earning a living while it's being repaired, that's
exactly
significant knock-on losses we're talking about. And I mean, obviously, Wendy, it's not his fault. If he was parked in a legal parking bay, it shouldn't have happened. It's nothing that he did to cause the accident. One would think he shouldn't have to pay that amount. But then who does, if it was a genuine accident? Who did he try to claim from?
So everyone, basically, one after the other. And I think what you said here is the nub, because the reasonable response from somebody in that position is, it wasn't my fault. Why should I have to pay for this? Why, if you insured yourself, why should I have to lose my no-claim bonus? Why should I have to pay the excess? It was not my fault. And so that's the premise where these things start. And whether it's I'm sticking with supermarkets, whether you've slipped and fallen on a bit of spilt oil or whether you've had a trolley damage your car, it's that really understandable reaction of I didn't cause this. It's not my fault. Somebody else must pay. So ShopRite referred it. He obviously went first to ShopRite. It was a ShopRite trolley or Checkers trolley, I think. But, ShopRite
part of the ShopRite group,
Checkers. ShopRite referred it to the company which they contract to manage its trolleys, which is Horizon Trolley Management. That company... he also then went to their Horizon's claims handlers, AGM risk management consultants. They took it to Horace's insurer, which was Bright. And finally, on the 27th of July, which was about
6 weeks later,
Bright contacted Michael to say there's no evidence to support any negligence or liability on the part of our insured. And then, just for good measure, a claims specialist writing on behalf of ShopRite declined it as well.
So let's just revisit here on what grounds the claim was declined. So again, when you can understand, ShopRite didn't deliberately place the trolley there and deliberately cause the accident either.
No.
But the immediate red flag for me is if there is a company which is tasked with and paid to manage your trolleys, one would expect that there would be some sort of sense of liability.
Yeah, so you need to look at like the circumstances of that orphaned trolley.
Yeah.
How are they managing? That's why you'll see, you will often see the better run shopping centres, you will see that, you don't have to take back the trolley yourself, because someone will take it straight from you. Yeah. So the other complication in this case is that Michael was given 4 different accounts of what happened. So Bright said there was no evidence of negligence. AGM said that a City of Cape Town employee was collecting refuse bags off the pavement. The trolley was standing in front of the bag, so he pushed it out of the way, and that sent it rolling into the car. And so AGM concluded that the liability rests with the City of Cape Town employee. The letter from ShopRite's claims specialist said ShopRite can't be held liable for an act of God where a trolley is blown by the wind, or if it was caused by another customer who just left the trolley there. And in the same letter, they opened by saying, our investigation into the incident reveals that an unattended shopping trolley entered a public roadway and collided with a stationary vehicle, causing substantial damage. So was it a careless customer? Was it that municipal employee? Was what? Basically, I think nobody really knew for sure. There was no CCTV footage, and so
there was that good Samaritan who'd waited to tell Michael.
And I didn't interrogate Michael on that and what they had said. I was just thinking about it as we started speaking, so sorry about that. But whether they actually saw it or whether they sort of came upon it as the trolley was already against it, I'm not sure. But suffice it to say that but there was no really hard evidence as to what had caused the trolley to connect with Michael's car and caused the damage. So the store manager photographed the trolley and the damage at the scene. Michael was never given those photos, though, when he asked for them, or the guard's statement, or any store incident report, and which is unfortunate because all those 3 things were used to deny his claim.
A security guard from
there was apparently a
the
statement.
Area. Okay,
yeah.
So he wasn't given access to the statements.
No,
okay.
He said he was only told towards the end of a phone call with the claims handler that the call was being recorded. They then relied on their own account of that call to say that he changed his story and refused him a copy. So it started getting very messy.
Yeah.
And then they stopped dealing with him altogether on the basis that he wasn't the registered owner of the car, even though, as I said, he has a letter from the owner confirming that he rents the car. He's an Uber driver. It's not an unusual situation. And the contract states that he has possession of the car and carries responsibility for it. And then on the 27th of July as well, the claims handler told him not to contact ShopRite directly because ShopRite had been instructed by the insurer not to enter into any communications or negotiations with him regarding the matter.
That's standard practice. Yeah. I've had that when somebody rolled into my car and damaged it, where I was told, stop, insurers will sort out, you do not engage directly.
That network for. Yeah.
Okay, so Wendy, I'm sure everyone feels the sense of unfairness to Michael. It's not something he caused. The financial ramifications are going to be huge for somebody who relies on that car for their business. So you took it up with ShopRite. What did they tell you in your correspondence?
Okay. So perhaps I should cut to the chase and state that, and I got this news just a few hours ago, that they are going to be giving Michael 9,372 Rand, which was the lower of the quote. And he's shared the news with me this morning as well, independently, and the forms that he was given. He's, of course, delighted with that and very relieved. ShopRite's statement to me read, we have elected to resolve this matter directly with our customer, and this is the important part, on an ex gratia basis. In other words, they're not accepting any liability, but under the circumstances, they feel that that's
as a gesture of goodwill.
Exactly.
Yeah. Okay.
This decision was made in recognition of the customer's experience and the protracted nature of the claims process, and should not be interpreted as an admission of guilt, negligence, or liability. So they're very clear about that. Each incident is assessed on its own merits. Trolley-related incidents are considered on a case-by-case basis. In this instance, the incident occurred in a public parking area where trolley collection and management are the responsibility of a contracted third party. The investigation found that the trolley had been moved while refuse was collected in the area, after which it rolled into the vehicle. Based on the available evidence, neither the third party nor its insurers found grounds to establish liability. And then finally, while the findings of the investigation did not establish liability on our part or that of the trolley collection and management company, we recognize the frustration experienced by the customer and acknowledge that the involvement of multiple parties resulted in a complicated and protracted claims process. So well done, ShopRite.
Yeah.
I mean, there was no liability established. We couldn't there was no way to prove that the trolley management company had erred in any way. And so, this is a good outcome.
They've done the good thing, the kind thing.
They've done the kind thing.
And all's well that ends well for this particular case. But of course, the bigger question here is talking around liability and, were those parties justified in denying liability, and who is actually responsible for that trolley when it leaves the store? And listening into everything so far and standing by to chat to those bigger issues, it's a huge pleasure to have with us on the show today Simon Coleman, who is a specialist liability underwriter, CEO of the liability company. And Simon, Wendy tells me you're known in the industry as the liability guy, so I can't think of a better person to have on the show. Welcome.
Thank you, Pippa. I'm also known as Christelle's husband. I appreciate being announced in my own right.
Also,
thanks for having me.
It's a pleasure to have the other half on as a guest for a change.
Yeah.
Over to you, Wendy.
Okay. Thanks very much for being with us, Simon. In your world, a runaway trolley or a slip on a wet aisle inside the supermarket are the same kind of problem. And to cut to the chase, who actually carries that risk of the injury and the car damage?
Look, I mean, every property owner has a responsibility to provide a safe environment for their customers. And certainly the companies that you mentioned earlier would endeavor to do that. I mean, given that you've got, hundreds of thousands, if not millions of people kind of walking through these spaces. So it's not an easy task for them. And I think that's why, one always has to come back to negligence. And I liked when you were talking earlier, you were saying, something bad happens to you and you want somebody to be responsible for it. If somebody drives into your car, that's a pretty easy one because you saw it happen, you know who did it, and you know that their insurers, if they have insurance, are going to make good on it. But in the property owning space, there's often large sort of time gaps between, something like a trolley moving out of the place that it's supposed to be in and then it being noticed or before the next round of trolley retrievers come back. So the courts are very specific in looking at, could it have reasonably been foreseen that something could go wrong, and then what did the property owner do about it to try and avoid that? Were there reasonable precautions that they could have taken? And I think with the trolley instances, you mentioned some shopping centers somehow have the resources and the capabilities of almost following every shopper and making sure that the trolley goes straight back to the store. But that's not always possible, especially when you've got those sort of high footfall areas. So it would be tempting to say the big business, the property owner, has to be responsible for everything that goes wrong on their premises. But we have to look at whether they're reasonably able to do what's expected here. And I think in this instance, I was very glad to hear that the supermarket decided to make good on this. But I couldn't disagree with some of the things that were coming from, the various parties. They felt that they weren't actually negligent. So it's never clear cut. And I think somebody said, we base these things, each case on its own merits. And that's absolutely how we do it. As a liability specialist, we look at each case individually.
Simon, we're going to break in a second for the news, but we will come back to you for some more general questions. But just quickly, I mean, you've raised an important issue there. What would be foreseeable and reasonable? A trolley is a vehicle in motion on wheels. It's reasonable to assume that if it's not properly stowed away, it will move. But as you said, you can't expect every store to follow every single individual trolley. Would it be different if, for example, on that day there'd been massively strong winds blowing, and it was then reasonable to expect that there is a heightened risk on that day? I'm just playing devil's advocate here. Would factors like that change the picture?
They might, but one would also have to ask, well, what could you do if there was this high wind? Stop people from using trolleys? It's not really practical. Or get extra staff. So, you have to look at both sides of this.
We're going to pause there to go to news, but Simon Coleman, please stay on the line because we've got quite a few extra follow-up questions for you. I can see a listener wants to share her own experience of a very similar incident and how it was handled. And we've also got an interesting email in from a listener on a very similar theme, which I'd like to get Simon's weigh in on.
Streaming countrywide on Prime Media Plus.
On DSTV channel 885 and across the city
On 567 AM.
So let's drive straight back into the Consumer Talk conversation about trolley damage and who bears liability in supermarket shopping parking lots, etc. Before the break, we heard that story of the Uber driver whose car was damaged by a runaway trolley through no fault of his own, and really through no fault of anybody's by the sounds of things, except perhaps the person who moved it out the way and didn't properly secure it, if indeed that's what's happened. On the line with us, Simon Coleman, specialist liability underwriter and CEO of the Liability Company, and thanks for holding through the news. Simon, before the break, you were just saying, it's about what was foreseeable, what would reasonably be expected of the supermarket in terms of taking responsibility for the trolleys after they've left the shop, etc. What would somebody need to prove in order to hold the supermarket liable, for example? What would they need to be able to demonstrate to really be assured of a claim being paid?
So you could show that there was foreseeability, perhaps some prior knowledge that there'd been similar incidents, and that reasonable precautions weren't taken to prevent this from happening. Mm-hmm. There's actually a very interesting case, if you'll permit me, which goes back to 2021, I believe, and that was the case of Pick and Pay versus Pillay. So this went to the Supreme Court of Appeal ultimately. Yeah. But what happened in this instance was Mrs. Pillay was kind of walking through, as you often see in an underground parking, she was walking through a boomed area back to her car, and she wasn't really paying attention to where she was walking, so she'd kind of veered off into the car lane, and of course someone had just gone out, and the boom actually hit her on the head when it was coming down. Yeah, terrible. So she was injured, and so she tried to hold Pick and Pay liable. She was actually successful in her claim, and the reason why she was is because it was held that, or proven rather, that Pick and Pay knew about this problem. There'd been quite a few similar incidents prior to this one, and they didn't really do enough to prevent it from happening. To prevent pedestrians from walking in that lane would have been a good starting point. Also important, just for interest's sake, was that Mrs. Pillay was held to be contributory negligence, so contributarily negligence, I should say, because I'm not sure exactly why she wasn't paying attention, but I'm assuming it's like I do myself. I'm often on my phone, not particularly watching where I'm going. So she had to bear some of the responsibility, and the court eventually decided on a 60-40 split, with 60% falling onto the shoulders of Pick and Pay, which they ultimately had to pay. So I think it's not exactly the same as the trolley incident, but it does kind of give you some idea of what can be done and what ought to be done to prevent the injury or the damage. And I think with trolleys, you'll find that these kind of incidents happen on a fairly frequent basis. And I don't know anything about that particular case that you mentioned, but the trolley retrieval company was obviously hired to specifically take care of this particular problem. So I can't imagine what went wrong in that context.
Yeah. Simon, if I may, let me put another case to you, because a listener mailed me this morning with I think very pertinent to what you've just said about predictability and foreknowledge. They wrote in to say the business park in which she works has just put up a disclaimer notice, and it's a pretty standard notice of disclaimer saying the owner of these premises and their shareholders, directors, etc., shall not be liable in any way for any loss, injury or damage, etc., etc. It's a long, long waiver. Vehicles are parked entirely at owner's risk. And her question is, can they really exempt themselves from risk like that if it's due to their own negligence? She says, one of my vans has previously been scratched in this parking lot when some metal sheets came off the wall during a storm. They had come off before, and I had to rush to the office to move my vehicle in that case after a fellow tenant called me. So they were aware of the fact that sheeting was loose. Surely in a case like that, which what she considers gross negligence, she said it's happened before, they didn't fix the sheeting properly. Can they really just shrug their shoulders and point to a disclaimer notice saying, sorry, no liability at all?
No. I mean, it's back in the days when I started working in the liability game, the disclaimers were almost like magical charms, that would ward off any kind of litigation. But that certainly changed and probably spurred on a little. Wendy may know more, just from the Consumer Protection Act coming out in around about 2010, 2011. So what we're seeing now is, the court's really looking at the positioning of the signs, the specific wording, and what are the risks that are specifically being warned against or contracted out of. And I think the sort of the case that most lawyers would refer to when they're sort of examining the efficacy of these disclaimers is that Birchwood case. I think it was Naidu versus Birchwood up in Joburg, where someone was injured while they were trying to open a heavy metal gate, and they were quite badly injured. The gate had been closed because it was after hours or something like that. And the court in that case said, look, you couldn't reasonably expect to be injured in this way when you were entering the premises of a hotel or a conference center. So you couldn't really accept that responsibility that was being thrust upon you by the disclaimer. And I think that's an important one. I mean, I'm reluctant to say that particular sign that you're referring to has no merits, or is not going to provide any protection to the property owner or unfairly prejudices the customer or the consumer. But I do think that one has to look at, what are the risks here? It sounds to me, just on the surface, you would not expect for metal sheeting to strike you when you're in a parking lot or entering or exiting a building. So I'm not sure how effective that sign is going to be.
I think as well the fact that it happened before and then clearly significant steps weren't taken to secure them in order to prevent a repeat, I think that would stand someone in very good stead with a claim. Okay. But, those things can be costly and time-consuming, and it's just unfortunate when companies don't take responsibility in those kind of fairly clear-cut cases, I think, and just point to a sign.
Some years ago, Wendy, I was attending a conference in the Drakensberg, and I remember the sign in the parking lot. It said something like, don't pat the white dog because he bites. And someone considered that sufficient warning, rather than locking the dog away where it couldn't actually bite people.
Very good example.
Yeah. So just to wrap up with you, Simon, I mean, Wendy, in this particular case, all's well that ends well for Michael. ShopRite has done a good thing in saying we recognise you've been through weeks and weeks of backwards and forwards and multiple parties not communicating well. Yeah. We're going to help you settle, which is great. But you wanted to just ask Simon a question or two around the sort of the shift he has seen in the business around these kinds of claims and whether we are seeing people trying to take advantage of them to some extent.
Yes, I think
what did you want to know?
Yeah, Simon, we chatted off air a little earlier, and you said, having been in the game for 35 years, you've seen quite an interesting, sad, I suppose, shift when it comes to these liability claims, because the companies are dealing with a fairly significant level of fraudulent claims, which is spoiling it for the rest of us, because it's making them introduced a lot of hoops for people to jump into with such claims. Would you just briefly go into that for us, please?
Yeah, I mean, thank you, Wendy. One of the examples that springs to mind is, the shopper returns to their vehicle and it's dented, and there's a trolley kind of in the dent. So it seems fairly obvious what's happened. But when the shopping centre owners viewed the CCTV footage, they actually noticed that another car had actually struck the vehicle. And then the owner of that vehicle, the guilty party, sort of got out as if to inspect the damage, and then just pushed a trolley into the damaged area and then drove off. Which is, again, why one cannot assume just because there's something that happened on the property that the shopping centre was liable. But in terms of, fraudulent claims being made by consumers, this is something that retailers have noticed and are keeping an eye on, where you've got people engineering slip and trip claims, for instance, slip and trip artists, as they're called in the
Taught
US.
me something.
Yeah, this would be someone who, has a small bottle of oil in their pocket.
Oh, no.
They would go into an aisle, and when there's no one in the aisle, squirt the liquid on the floor, and then as soon as the next customer comes around the corner, they would slip on it themselves and fake a back injury. So those kind of things are happening more and more frequently, and as one would expect, when you're in tough economic times, you do see an increase in insurance fraud. I mean, there's a correlation between the two. So I think you're finding that whilst I would like to believe that the big businesses that we give our hard-earned cash to, when we're buying their products and services, that they care about us, they don't rush out settlements or, immediately accept responsibility, because they have to be careful of every incident, and that they're not sort of opening up the floodgates, being easy targets to fraudsters. I'm definitely not suggesting that's what happened in Michael's case here, but you need to understand, I think, that businesses have to also perhaps become a little more cynical in this type of environment.
Okay.
What a shame.
Isn't that a pity? Yeah. Just in closing, Simon, any advice for everyone listening today? Hopefully nobody has Michael's kind of experience of an orphaned trolley damaging their car or a genuine slip happening in a supermarket. But if it does happen to you, any advice on what sort of evidence one should collect at the scene, what sort of steps one should follow in the immediate aftermath to improve your chances of being able to claim if somebody was indeed liable?
I know it's very difficult to do this, but you should almost apply the same thinking that you would if you were in a car accident. So you want to get photographs if you can. Most shopping centres have the security guards around to take statements. So you need to make sure you go through all of those processes. If you can get copies and find out what the next step is, who's going to be dealing with it next, then that is also ideal. I'm afraid it's not ever going to be a streamlined process, though. It's going to be disjointed. There'll be different people involved. And I guess the last thing that you would do if you don't get any joy is to go to the small claims court, or to go and see an attorney if the claim is sufficiently large.
On that point, just to share with our listeners, I don't know if we have already, but from this month, the maximum amount that the small claims court can preside over has risen from 20,000 to 30,000.
Oh, I didn't know that.
Yeah,
there'd been another jump.
So it's quite a significant jump, and it will, be able to deal with a lot more cases than up till now.
Glad you mentioned it. Wendy, thanks for that. And Simon Coleman, thank you so much for joining us on the show today and just giving us that contextual understanding for the issue we've been talking about. Really a pleasure to have the other Coleman on with us as a guest, and I hope it won't be the last time.
My pleasure.
Thank you so much. Simon Coleman, specialist liability underwriter and CEO of the liability company. Okay, so all's well that ends well for Michael. I'm smiling at Helen's message. She's saying some years ago a woman bumped the boom at Pick n Pay Claremont in the parking lot with her car and actually knocked the boom off its supports. Thankfully no injuries, but there was quite a car queue build up behind her. She said we were most amused while sitting in that queue to notice that the advertising on the boom was for the local optometrist. Clearly she had need of their services is the bottom line. We've got a voice note in from a listener who has had a similar experience to Simon's at a different supermarket and had a slightly different sounding outcome, if I'm reading the summary correctly. Let's take a listen to what Sue had to share.
Time ago, a freewheeling trolley did go crashing into my car. It was one that someone had parked somewhere and had just decided to move because it wasn't so securely parked. And it went crashing into my back bumper, and it did cause damage. And I wrote to Pick n Pay, and the trolley, because the trolley had Pick n Pay written on it, and I just described the circumstance. There were no witnesses or anything. I just said it was a Pick n Pay trolley, and they actually paid the damages, which weren't much because it was the bumper, but they paid it without question. My nephew, who's an advocate, he was quite amazed that my argument was simply it was a Pick n Pay trolley, and that did the job of getting the refund. Thank you. Bye.
Well, I'm so glad that it had that outcome. Yeah.
Took a decision to trust that her account was accurate and go with it, which is great. Because in most cases, it's going to be completely genuine.
Yeah.
It's just those rogue ones that spoil it for the rest of us. So that is very nice to hear. Thank you.
I love it. Well, yeah, Trevor, absolutely agree. Trevor's saying it irritates me so that people leave their trolleys all over the place. I always return the trolley after use, but people even leave them in parking bays. It really irks me.
So selfish.
If you take nothing else away from today's conversation, I hope it makes you more mindful of the fact that it's not just, it's a pain to take it across the shopping mall. It's a couple of meters for you to walk. It potentially saves somebody like Michael from having his livelihood interfered with. Never mind the hassle of what he's been through.
And also to give credit to car guards. I mean, they're mainly wanting tips from us, but in so many cases, they
play this role.
I try to walk my talk. I will take my trolley back. But in most cases, a car guard will take it from you. Yeah. And I think they have prevented many of these orphan trolleys incidents. So,
be mindful of that as well.
Credit them.
Join the conversation. You're with CapeTalk.
Well, Wendy, just to follow up from the listener who mailed us about that business park disclaimer notice saying, thank you so much. I appreciate your talking about it. But this is the pertinent point. I'm glad we don't need to accept these people bullying us when we actually have rights.
Exactly. CPA, you can't contract out of your own negligence.
So
you can sign all these disclaimers. Even when we send our kids on these excursions or whatever, you have to sign. If blatant negligence was at play and that caused injury to your child, that little notice that you signed, it has no validity.
If it is due to their direct negligence. Yeah. So that's the bottom line. Thank you. And I'm so glad you raised the issue while Simon was with us. Thanks for the mail. I think we can squeeze in. Yeah, we've got a couple of minutes to do some open line. But first, a voice note in from Bruce, specifically relating to a similar incident, I think.
A quick question. I was involved, my car was involved in a bit of a crash at a parking shopping centre. And when I went to get the evidence from the shopping centre security, they cited that they couldn't release any footage to me because of Poppy. Is this correct? What legal standing do I have?
Well, okay, Wendy's not a lawyer. Disclaimer.
Thank you.
Disclaimer,
you took the words out of my mouth, but I would certainly push back against that. I think that's not what the act was designed for. Yeah. So I would say you have suffered harm, and they have potentially have evidence that would help you get justice. and it is unfair of them to. I mean, it involves you. It's your information.
Yeah.
I would certainly push back hard. Come to me with such a case, and because I don't think it's a justified response.
Yeah. Okay. Thanks. Thanks for that, Bruce. Okay. Pat in Parow North raising one of your favourite subjects, Wendy, shrinkflation.
Oh, yes.
And she wants to just add an item to the list of products suffering from shrinkflation. For those who don't know Wendy's favourite term, it's when our favourite products don't necessarily go up in price. They might stay the same price, but the amount of product you're getting for that same price sneakily goes down. We've seen it happen with everything from tomato sauce to cool drinks to soap. Little dings, and in this case tissues. Pat wants to flag, she says, I only use 3-ply tissues, mostly from Clicks. Lately I've noticed that the size of the tissues seems to be getting smaller. The box is still the same size, but the tissues inside it are much smaller. Have you noticed that, Wendy?
I've noticed it, and many other consumers have told me about other brands as well. So it's normally when they haven't quite finished an old box, and then they have the evidence because they get the ruler out and they're like, oh yes, this is
new one is short
centimetre. Yes, so they've all done it. It's classic shrinkflation. The other thing that happens is skimpflation.
Yeah,
mainly with food. So and sometimes they do both, horrifyingly, where they reduce the amount of premium ingredient. So a chicken pie will have less chicken, more gravy, that kind of thing, and then. So the quality of the layers of tissue, they might get thinner. So it's still 3-ply in this case, but it's not as luxurious
as it used
tissue
to be.
As it used to be. Yeah.
I'm going to add a product too, because I opened a box of biscuits last night and I looked at the biscuits and I thought, gosh, I feel like I need a microscope to see the Eat Some More biscuits. The little square is definitely smaller than it used to be.
You get
Wendy.
the mini ones. You're not confusing them with
not like not miniature ones.
But
it was
smaller.
a normal looking box. That's what I want to add for investigation.
Okay,
please.
I'll take it up.
Okay, because it's been quite some time since I purchased the product. I got it as part of a bundle deal,
so that's why you
with something else. So it was very noticeable to me that the size of the biscuit, not only in terms of the width and breadth dimension, but also the height felt. It just felt like it was skimpier than it used to be.
That's so disappointing. Why do that? Because the trend, where does it end, I'm asking?
Yeah.
At some point, everything can't be minis to make them, as the industry puts it, more affordable, by which we think it's the same product but cheaper. But they mean we're giving you
a lower price tag, but it's because you're getting much less for it. Yeah,
exactly.
So the price per kilogram has actually gone up.
The story that I had the most reaction to of last year was one about the shrinkflation applied 2 ways to the Magnum box of minis.
Yes.
So there were 6 in the box, and then they reduced it to 5, and they reduced the size of the remaining 5. So it worked out, I can't remember the percentage offhand, but the percentage less product you were getting in that box was substantial. And it also messed with families who were relying on 6 in the box to divide, between them or whatever. Now suddenly there's this odd number. If you've got 3 children, I suppose it's great.
It's fine, but if you have 2 or 4...
It was just,
I'm trying to imagine having to referee that particular argument. It's a tough
audiences just went crazy for that story. I've written, bank fraud and rip-offs and whatever, but that
Don't
Magnum
touch us
minis,
on our Magnum Mini.
So the Mini, first of all, that product's called Magnum. And you've got minis that got even minier. I mean, it's just...
Do keep flagging these, please, because I think it is important to point it out and call it out when you see it, so that they don't think they can get away with doing it surreptitiously and pulling the wool over our eyes. We see you for the smaller biscuit. I had to have 2, Wendy, and then I couldn't sleep for the guilt all night. So there we go. Okay.
So unfair.
So bad. We're going to leave it there with a reminder that if you want to raise a case with Wendy, you can go to her website, wendyknowler.co.za, spelled Knowler. You can fill out the contact form there, which is designed to extract all the relevant information from you. So it really is the best way to do it. But if you really can't make that work, you are welcome to send an email to consumer@knowler.co.za, and please just put the words CapeTalk in the subject line. We'll leave it there, Wendy. Look forward to having you back with us next week.
Indeed. Thanks, Pippa.